Welcome, I'm Russell Alexander. On our YouTube channel, on our blog, we're going to take a look at the children's consent to therapeutic treatment and how it was recently examined by the Court of Appeal. Before we take this deep dive, I want to give you our COVID case of the day. The question is, if you sell your home and your sale proceeds are being held up, can you get them released to you by way of a court order? Is it considered an emergency or an urgent matter? Stay tuned to the end of the video to find out the answer to that question. So let's get at it. What we're looking at here is the Provincial Healthcare Consent Act. Whether someone requires somebody to give their consent before treatment can occur. And it falls within certain prescribed circumstances. So here we have a dispute over a 14-year-old boy, and the court examined his powers to determine whether the child could be ordered to undergo therapeutic treatment even against his will. So there was some evidence that the child was being alienated by the mother. The child didn't want to see his father, and the mother had systematically and successfully poisoned the child's relationship with the father. The judge took a fairly incredible step by reversing the court order with access to the mother, with hope that the child would rebuild the relationship with his father. The judge acknowledged there's going to be short-term difficulties in reversing the court order, but he was worried about the long-term detrimental effects to the boy of not having a good relationship with his father. The mother had also shown no interest at all in participating in therapy throughout the court proceeding. The court ordered reunification therapy, which it does sometimes when one parent has separated or has attempted to alienate the child from the other parent. It has a therapeutic component to it. This is why the court considered the provisions of the Healthcare Consent Act and also the child's wishes and the fact that he did not want to participate. The Court of Appeal decided that the trial judge was right in not giving full weight to the child's wishes and ordered that therapeutic reunification continue. Where the parents don't agree, the legislation really does afford the court some broad discretion to make orders, as long as it's in the child's best interest, and that's what the court did here. It ordered the therapy over the objection and the wishes of the child. What do you think? Was this the right approach? Obviously, it's a fairly significant change in this young child's life, reversing custody and being ordered to go into therapy, but the court determined it was necessary so the child could have a good relationship with his father. Take a look at our blog where we take a deeper dive into this case and these issues. Thank you for watching this video. If you've liked this video, hit the check mark below, click like, you get the bell up, you can get notification of more videos that we have coming. If you have questions about this case or any other family law matter, including family law issues during the pandemic, please put your question in the box below. We're going to take all the questions that we get and assemble a video and try to answer each and every one of them. So I want to thank everybody for listening. Let's circle back to where we started. Can you get your sale proceeds released if they're sitting in trust after your home has sold? In this particular case, the wife brought an urgent and an emergency application to get the money paid out to her. The court dismissed that application and said no. Partly because the wife didn't provide full financial disclosure, and partly and mainly because the court determined at this point in time it wasn't an emergency or an urgent matter and didn't meet the test. Interesting outcome in that particular case. The wife should have done a more complete financial picture to show that it was urgent that she get her sale proceeds released. Thank you for joining us today. Thank you for watching our video today, and please be safe.